Good morning and welcome. For those of you who joined the live recording of this webinar, you might think that this looks a little different to what you were expecting. Unfortunately, I had a technical glitch right on the last bullet point during the live session, so this is a re-record, so bear with me till the end and hopefully we will get to that last bullet point. My name is Rowan Turrall and I'm a partner and the head of dispute resolution at Boyes Turner. And today's webinar for in-house lawyers is on the troublesome issue of termination. If you were to ask me what issues I see cropping up regularly in my work, then termination is probably up there as one of the main ones, but it appears in many different guises. It's yet another one of those areas where, even though the principles may seem to be fairly settled, the application of those principles to the facts can be hugely problematic. The starting point when faced with termination is to make sure that the business knows to come to speak to you first, so that you can assess the position before they take a step which backs you into a corner. They may be doing that because they assume they have a right to terminate when they don't. They do have a right to terminate, but they don't follow the correct contractual procedure, or they affirm a breach, which means that you can no longer accept it as bringing a contract to an end. I frequently see cases which only reach the legal team before it's too late and the damage has already been done. Step one, as ever then, is an education piece to ensure that these queries land on your desk at the appropriate time before others have interfered with them and the damage has been done. For today's purposes, I've chosen 4 recent cases to go through, which hopefully will give both a bit of an update on the court's recent approach to termination, but also highlight some of the areas where problems can arise and give some practical points to think about. I'm going to wrap up with what I hope are some further useful learning points based on things that have been on my desk. I appreciate as a litigator, I'm always looking at these issues with the slightly smug benefit of hindsight and picking holes in what people could have done better, rather than as somebody who's given a contract review an hour before it's due to be signed or handed a notice of termination 3 weeks after it's already been sent. But hopefully with some of these tips that I'm going to give you, I can help you to avoid getting into the same position. Some of the issues I'm going to talk about are ones that can be reviewed and headed off at the drafting stage potentially, and some of them at the point of termination itself. I wanted to highlight from going through these points, though, that it's not just at the time of actually terminating that things can go wrong. If you spend some time at the beginning on drafting, you may also be able to help mitigate the risk of some of those things going wrong at the end. So my first case that I'm going to be talking about today features a former stalwart of the High Street, the Body Shop, and one of its earliest franchisees, the Burke Partnership. Now, the reason that I've picked this case is to highlight the importance of understanding the term of your contract, who has the ability to terminate it, which may not be the same rights for both parties, and the extent to which the court will step in when there's an issue. The agreements in question are pretty old, dating back to the early days of the Body Shop, not long after Anita Roddick had opened the first store in Brighton. The first agreement related to a franchise for territory in Norwich, dated April 1981, and the second for a territory in Cambridge from September 1982, so both fairly old. 2 agreements, though, were in materially identical terms. The dispute that had arisen related to whether those agreements could continue to be extended by the Burke Partnership for ongoing 5-year periods, or whether the Body Shop had a right to terminate on reasonable notice. Up until that point, both agreements had been extended by the Burke Partnership for successive 5-year periods at the Burke Partnership's request in accordance with the terms of the contract, and I'll explain a little bit more about the terms shortly. When it came, though, to them requesting a further extension in December 2020, the request was refused by the Body Shop. And you'll see that I set out on the slide an extract from the wording of the letter, from which the Body Shop noted that the agreement was no longer fit for purpose. They decided as a result that the term of the agreement had been rendered indefinite, subject to termination under English law principles on reasonable notice. And having taken into account the long association between the 2 parties, Body Shop then gave a period of notice of 3 years. A similar letter was sent in relation to the Cambridge Agreement. There were 2 key issues before the court, and the one that I'm going to focus on is the second one of these, which was whether it was a term of the agreements, either on their true interpretation or by reason of implication of a term, that after the expiry of a reasonable period of time, the agreements were terminable by the Body Shop on notice. So to help frame the issue that was before the court, I've set out the key provisions on the slide. Firstly, we had clause 3, which dealt with the term and its renewal. from which you can see there is reference to the 5-year term and also a right to renew on giving at least 3 months' notice. Next up, we have clause 11, which provided a limited right of termination to the body shop. That first subclause essentially giving them various rights in relation to breaches that might occur, and the second one dealing with insolvency type events. The court adopted a two-stage approach to this element of the dispute, first by construing the meaning of the clause and then by considering whether a term could be implied. And approaching it in that way followed the approach of Lord Neuberger in the case of Marks and Spencers and BNP Paribas from 2015, which in summary said that you have to first decide what a contract means before you can decide whether you need to imply a further term into it. On the question of construction, the judge found that the agreements did not limit the Burke partnership to one single extension. Instead, it was entitled to give at least 3 months' notice before the expiration of the term that it wanted to renew for a further 5 years, and then it was entitled to do the same again at the end of each 5-year period. There are a number of reasons for the decision, and while the body shop tried to argue that the agreement could be renewed in perpetuity if this interpretation was correct, the judge disagreed with that analysis. He said there was a mechanism to be followed and the Burke partnership had to have complied with its obligations. Another reason was that Body Shop did have some ability to bring the agreements to an end. There were those express rights in clause 11 that I mentioned, and that gave them some rights to terminate. Lastly, even though commercial parties now may not be inclined to enter into an agreement with such one-sided termination rights, to construe the agreement on that basis would be to do so with hindsight or to retrospectively invoke common sense, neither of which the court was prepared to do. The judge therefore went on to see if a term could be implied that would give the body shop a right to terminate on reasonable notice after expiry of a reasonable time. The judge set out the key principles to be applied when implying a term, and I've not set them out here because you can glean them from the way in which the judge approached the issues. Having done so, he rejected the body shop's case on the following reasoning. He said that there was already an express provision for the determination of the agreements, which on his view did not continue in perpetuity, and so the implied term would conflict with those express provisions. One of the grounds for refusing to imply a term is if it would conflict with an express term. Next, the agreement didn't lack commercial or practical coherence without the implied term. Against the factual matrix at the time the agreements were entered into, it was not so obvious that it goes without saying. Next, the agreement put forward now by the body shop that the agreements were hopelessly out of date, such that there must be an implied term, was not one it could have advanced at the time the agreements were signed. The judge therefore granted declarations that the Burke partnership sought in its favour. So what are the key points to be considered from the case? In my view, one of the key themes is when you're looking at termination provisions and drafting to treat them like a prenup agreement. You hope that you are never going to be having to bring your relationship to an end in other than amicable circumstances, but you do need to think about your escape plan just in case. If you're going to be entering into a contract where the term can be renewed, how are you going to bring things to an end if circumstances change? This case demonstrates that if you have got some limited termination rights, then the court is going to be unlikely to interfere to imply terms to give you a get out of jail card and to give you further termination rights. It's also a useful point to mention at this time contracts which auto-renew by the giving of notice or by not giving a notice. If you supply services on the basis of contracts which renew automatically and a valid notice to terminate is not given, don't forget that there may be two options available to you. Firstly, you may be able to accept the notice of the repudiatory breach of contract and claim damages arising from wrongful termination. But another option, and one which is often overlooked, is that you may be able to affirm the contract and refuse to accept that the termination is valid. It's important to remember, though, that there are pros and cons to both options, depending on the particular factual circumstances and the business scenario at the particular time. If a termination notice lands, though, and you think that inadequate notice has been given, then pause before simply accepting it to assess whether that is actually going to be the best option. But remember, don't leave it too long before making a decision and don't take any steps which are inconsistent with your position. So the next case that I'm going to look at is Toppleton and Rolls-Royce, and it's quite a lengthy and complex case arising out of a dispute regarding the development and supply of software for a new car configurator. Again, there were various issues before the court, but I've just pulled out the relevant ones in relation to termination, but well worth a read if you were involved more generally in technology disputes. I'm not going to go into the detail of the project other than to say that it didn't stay on track for various reasons which formed part of the dispute. The agreement included provisions for Rolls-Royce to terminate in the event of Toppleson's default, which I've set out on the slide. And there was also a right to terminate for convenience by exercising 6 months prior written notice. So Rolls-Royce first purported to terminate the agreement by a letter dated 16th of April 2020, and I've set out an extract from the notice on the slide. You'll see it was a notice to terminate with immediate effect, with a reference to time being of the essence and a failure to comply with relevant dates. Topson wrote to Rolls-Royce formally rejecting that notice. They stated that they formally rejected it on the basis that they considered Rolls-Royce did not have a right to terminate, either at common law or in accordance with the contract. And having not validly terminated it, it was decided by Topson that they were not going to accept that incorrect notice, and they considered that the contract continued, and they affirmed it. So on the 22nd of April 2020, Rolls-Royce had another go and served a second notice of termination without prejudice to its contention that the first notice was nonetheless valid. Again, I've set out an extract from the key points of the latter. Topson, this time though, decided that it was going to dispute Rolls-Royce's right to terminate, but this time treat the notice as repudiation of the agreement. Its solicitors then set a follow-up letter which said the agreement was not effectively terminated by either the first termination notice or the second termination notice, and Rolls-Royce was therefore in repudiatory breach of the agreement as a result of its wrongful termination. Topson therefore elects to accept Rolls-Royce's repudiatory breach and hereby terminates the agreement with immediate effect. So different approach second time round to first time round, and as a consequence, Topson this time decided to issue proceedings. And one of the key issues before the court was whether Rolls-Royce had been entitled to terminate either under the contract or at common law. In relation to that first notice, Rolls-Royce had in fact erroneously relied on dates for delivery which had been revised, but the judge said that was immaterial here because Topson had rejected that notice and Rolls-Royce had then gone on to serve the second notice. Looking firstly at the contractual provisions to terminate, Rolls-Royce could terminate for failure to perform the services in accordance with the agreement or to deliver deliverables by the applicable delivery dates. The problem for Topson here was that as far as delivery was concerned, time was of the essence, that having been stated in the contract and also by Rolls-Royce when it agreed to an earlier extension of the delivery timescale with a reduced scope. The judge set out an extract from the judgment of Lord Justice Mustill in the case of Lombard North Central and Butterworth from 1987, highlighting that where time is of the essence, it is a condition of the contract, and therefore delay in performance is treated as going to the root of the contract without regard to the magnitude of the breach. I thought it would be useful to paraphrase the extract on the slide because it serves as a useful reminder of the interplay between time being of the essence and termination. So firstly, where a breach goes to the root of the contract, the injured party may elect to put an end to the contract. If the injured party does terminate, they have a right to compensation for breaches which occurred before termination and the loss of opportunity to receive performance of outstanding obligations. Conditions have the property that any breach of them is treated as going to the root of the contract. Upon breach, the injured party can elect to terminate, no matter the gravity of the breach. An express provision can make a term a condition, even if it would not be in the absence of such a provision. A stipulation that time is of the essence makes it a condition. Failure to meet a time of the essence provision gives the injured party the election to terminate and claim damages without regard to the magnitude of the breach, and the innocent party in such circumstances is not obliged to accept late performance absent any waiver or estoppel. The judge therefore found that that second termination notice was valid. The express terms of the agreement had made time of the essence, and failure to meet the delivery dates amounted to a breach of the condition, entitling Rolls-Royce to terminate either under the clause or at common law for repudiatory breach. Now, the reason I included this case was to serve particularly as a reminder of what happens when time is of the essence in a contract. The expression time of the essence is often thrown around in the sense that something is urgent, but it's important to remember that time being of the essence has a particular effect under the contract. If your business is entering into a contract where you are delivering to a deadline where time is of the essence, it's crucial that they understand the implications of not meeting the deadline and what that might mean in terms of termination. On the flip side, if you're receiving goods or services and the delivery is not made in accordance with the time of the essence provision, it's important that the business understands its rights. It's possible to lose the right to terminate in these circumstances through waiver and estoppel type arguments. There may be legitimate reasons why termination is not the right option, even if it is available. But this is an area where thought needs to be given before a decision is made, rather than when it's too late. It's also important to remember, as I mentioned in that checklist of the case, to remember that other provisions that would not ordinarily be conditions of the contract can be given that effect by the parties in the contract. Breach of that clause will then give a right to terminate regardless how serious that breach is. So do watch out for those types of clauses in your contracts as well. And the same position applies in relation to those, in relation to enforcement of them, either being on the wrong end of one or making sure that if you do have a right to terminate in light of breach of one of those, that those rights are not waived. So the next case I picked up is the slightly older case of Olympic Council of Asia and Novens Jets from 2022. The reason for picking this case is it helps address the issue of what to do or what not to do if you think that the other party to the contract has given up on performance. Again, it's another tricky area. Get it wrong and you end up in a situation where you've wrongfully terminated the contract rather than successfully bringing it to the end on the basis of the other party's default. This particular case concerns the termination of an aircraft lease to purchase agreement. No need to know anything particular about the background here. There were various issues before the court, and again, I focused on those dealing with termination. The judge noticed various extracts from Chitty on Contract to set the background to the relevant legal principles, and I set out some of the key ones on the slide by way of reminder. And then at the end, Chitty summarised the test as being a straightforward one to set out, namely whether looking at all the circumstances objectively, that is from the perspective of a reasonable person in the position of the innocent party, the contract breaker has clearly shown an intention to abandon and altogether to refuse to perform the contract. So having said that there is a test to be applied, which is straightforward, unfortunately, the next sentence from Chitty takes us back a stage, saying it is the application of this test to the facts of individual cases which has proved to be less than straightforward. So what happened here? Although the judgment sets out the chronology in detail, the salient fact that we need to know for today is that Novens issued to OCA an invoice which was disputed. The invoice had not been paid, and there were various communications sent by OCA and attempts by them to arrange meetings with Novens to try to address various queries regarding the disputed invoice. Eventually, Novens served notice purporting to terminate the agreement for non-payment of the disputed invoice. OCA then issued proceedings claiming that Novens had breached the agreement, including by purporting to terminate, and in those proceedings they sought just under $7 million. Novens argued that the sums invoiced under the disputed invoice were payable and that failure to pay the amount amounted to a repudiatory breach. It argued that it had accepted that breach in reliance on its rights under common law and the termination provisions in the agreement. For today, though, I'm only going to focus on the arguments around its common law rights. OCA's submission on the termination point that was it not in repudiatory breach, having never evinced an intention not to perform its obligations. It had legitimate disputes and queries on the disputed invoice, which it was seeking to resolve, and OCA never engaged with it on this point. OCA said it was not refusing to perform and wanted to perform, but it wanted to resolve the queries. It said the breach had to be sufficiently grave and sufficiently unexplained as to amount to an intention or the evincing of an intention not to be bound. Novens' case was that OCA was in repudiatory breach because it had continually and deliberately failed to pay the disputed invoice, which amounted to a clear intention no longer to be bound. It had made multiple requests for payment and OCA had refused to pay, making various excuses, none of which had any merit. So in the discussion of the points, the judge noted that the requests for payments had been met with immediate responses seeking meetings and clarification. The judge considered that whilst OCA was in breach of its obligation to pay, its actions were not such as to lead a reasonable person to conclude that it no longer intended to be bound by the provisions of the contract. The documentary evidence before the judge demonstrated that the parties were continuing to operate the contract whilst at the same time seeking to discuss the various issues between the parties. Although it hadn't paid the disputed invoice, OCA had made instalment payments, and the disputed invoice was only for some $200,000, which in the context of the overall contract could not said to have evinced an intention not to perform the contract in such a way as would deprive Novans of substantially the whole benefit of the contract. On the question of repudiatory breach, the judge found that the test I outlined above was not met. From the perspective of a reasonable person, OCA did not show an intention to abandon the contract, and nor did it refuse to perform. Novums was therefore not entitled to treat the contract as repudiated. So the main thread to be drawn from this case is, as ever, to tread particularly carefully if you are faced with a situation where you do not have a very clear and unambiguous representation from the other party that they are unable to perform. Even in that instance, check very carefully before jumping on termination. Even though I mentioned the test which was set out in Chitty, even Chitty acknowledges it can be a difficult one to apply. And this is a key theme with all areas of termination. So much is dependent on the particular facts and circumstances of your individual case, and often our good friend, the reasonable person, is thrown into the mix to provide an opinion. It can make it very hard in practice to make a decision about whether particular conduct does in fact give rise to a right to terminate, and there is often a substantial grey area where things could go either way. As ever, though, getting it wrong can result in a wrongful termination. So, particularly on contracts with high values at stake, it's worthwhile working through the various scenarios carefully and assess which outcome is going to be the most palatable to the business from a cost and a risk analysis perspective, as there may be more than one option available to you in relation to termination rights. You need to balance those different options for certainty of outcome and the financial consequences, and work out which one is going to be the most acceptable in the particular position with which you are faced. So the final case that I've chosen is a construction case relating to termination under a JCT contract. For those of you who don't deal with construction issues, it's one of the main standard forms used. That don't need to worry though, this isn't a construction focused case. The reason I've chose to include it, even though construction based, is that it related to a termination clause which required a notice of default to be given before a notice of termination could be served. I therefore thought there's some useful parallels that can be drawn from the case to clauses that you frequently see in other types of contracts where you have a requirement to serve first a notice to remedy breaches before a notice to terminate can be served. In this case, there had been an adjudication between Bellis and Sky House, and one of the issues which the adjudicator decided was whether Bellis had correctly followed the termination provisions in a JCT minor works contract. In particular, what the timing should have been for the service of a valid termination notice. The case came before the court because Mr. Bellis had sought a declaration that the termination notice he had served was in fact valid, and the court concluded it could address it through the mechanism of a Part 8 declaration. Clause 6.4 of the contract allowed for termination by the employer of the contractor's employment under various headings. The first stage of the process was to give a notice specifying the relevant default or defaults, and I've set out the wording of the clause on the slide. After that initial notice, it's open for the employer to serve a second notice in order to terminate the contractor's employment under the contract. But there is a timescale within which that needs to be done, and the key point in the case was the timing around when notice number 2 could be validly served after giving of that first warning notice. So in the case, Mr. Bellis had sent an email to the defendant on the evening of the 1st of September 2021. It was a first stage notice under clause 6.4 and indicated that a second notice would be served if the points were not addressed by Wednesday, 8th September. Although the notice was sent by email, the judge accepted Mr. Bellis's position that the email had been put into letter format and hand-delivered to the defendant's offices on the same day. The second notice was also sent by email on the 8th of September at 7:20 in the morning, and again was followed by a hard copy, which was hand-delivered to the defendant's offices. The defendant's position was that the termination notice was invalid because it had been sent too early, as the claimant was required to wait for 7 clear days after the date of that first warning notice. As a result, it argued that the earliest date on which the notice could be served was the 9th of September. Looking further at the contract provisions dealing with reckoning of time, the judge referred to clause 1.4 of the contract, which I've popped on the slide, and which stated that where under this contract an act is required to be done within a specified period of days after or from a specified date, the period shall begin immediately after that date. The judge thought it wasn't entirely obvious that this was supposed to also apply to the period between the service of a warning notice under clause 6.4.1 and the termination notice under 6.4.2. However, he considered that in common sense terms and commercial terms, the warning notice required the contractor to address specified defaults. The draftsman of the contract would have wanted there to be certainty on the timescale for compliance with that notice, and so would have wished for the contractual provision dealing with reckoning of periods of days to also be applicable to that clause. The claimant's interpretation of the clause would have allowed a warning notice to be given at 11:59 on the 1st of September and a termination notice at 12:01 in the morning on the 8th of September, which would have given the contractor just over 6 days to comply rather than 7. The judge stated that the contract should be read so as not to reduce the already tight timescale and to give both parties certainty as to how long the contractor has to act and when the employer can serve the notice of termination. In finding that the claimant had not given enough notice, the judge's primary reasoning was that clause 1.4 applied to the interpretation of the reference to 7 days, and as a result, the earliest day on which termination notice could have been given was the 9th of September. However, and a point that's particularly applicable to other contracts, was that if for some reason clause 1.4 was not applicable, then in view of the importance of the contractor having a full 7 days to address the issues included in the warning notice, he would have construed clause 6.4.2 as anyway requiring a period of 7 clear days, ending at midnight on the 8th of September 2021. Unfortunately then for Mr. Bellis, his notice of termination was sent 1 day too early. So here the case had only looked at the procedural aspects of whether the notice was served too early. It didn't even need to get into whether Mr. Bellis had actually got sufficient grounds for sending the warning notice or the termination notice. But by getting his timing wrong by just 1 day, his termination was invalid and unlawful because it was sent before any right to terminate could have arisen. So without wishing to labour the point, why does getting the timing wrong make a difference? Again, a valid right to terminate, which is messed up, can change a valid termination to a wrongful termination. It's one of those cases of snatching defeat from the jaws of victory. Termination is one of those minefield areas where significant problems can occur. And as I say, this particular case didn't even get as far as looking to see whether there were grounds to terminate. So the message is to tread very carefully if you are dealing with a case where you have to exercise a similar type of provision where you have a 2-stage termination clause, with the first step being a need to give a notice to remedy to be followed by a second termination notice. You need to make sure that you have very carefully calculated the time period during which the remedy period will run, and then subsequently when the first date is that the termination notice itself can be validly served. That's going to involve checking the notice provisions to ensure that both notices are served by a valid method, and also considering whether there is a deemed service provision tucked into the contract somewhere, which will then determine when that first notice is actually taken to be served, likewise with the second notice. So that concludes my case law review, and I'm going to move on now to a slide I've titled How to Avoid Your Contract Landing on My Desk. The reason for including this is that when it comes to terminating, you may anguish over whether you have a right to terminate, but it's also important to remember the actual method of termination. Making the decision about whether you actually have the right to terminate is normally the trickiest part of the termination process, but that's not always the case. And so for this hints and tips section, I've looked at some of the things that you may think are fairly basic, but are loosely based on things which have landed on my desk in recent months. So for the purposes of these tips, I've assumed that you have a contractual right to terminate that you are seeking to exercise, and you need to give your notice to terminate in writing. So first up, you have to think about the method of service. So important to check the notice provisions in the contract. Often pretty standard, but I had to advise on one recently where the notice provisions provided for notices to be served by fax or first class post. If anybody still does have a fax out there, I suspect you are in a huge minority, but it's surprising how many clauses that you still see that have a requirement that faxes may be served by fax. The problem in this particular case was that the recipient of the notice was in the US, and the ideal route to ensure that actually the notice was received would have been sent via courier. That arguably, though, might not have been valid service, and you don't want to create a problem where there doesn't need to be one. If you're sending out a new agreement then, which is subject to an older framework agreement, or your precedent agreement has got a bit out of date, it's worth checking the notice provisions to see if they need tidying up and refreshing. If you're likely to be contracting with overseas parties, think particularly about how it's easiest going to be to serve your organisation, and ensure that the wording of the clause expressly allows for it. Be careful though before jumping straight to using email as a method of service. Whilst that does get over many of the problems, it does cause some issues of its own, so do think carefully about what you are going to do in that regard. I've already mentioned the perils of calculating the date for termination following the service of notice of breach. However, if you've got rolling contracts which require notice to be given within a specified window to avoid renewal, make sure it's obvious what that window is going to be when you're drafting. That might include considering a deemed service provision, so there is no doubt as to how you are going to calculate the relevant period. Another issue which I've come across recently was in a contract which renewed, and there was confusion as to when the renewal date actually was going to be. So let's take a clause, for example, which says that the term will start on the commencement date and notice must be given no longer than 90 days before the anniversary of the commencement date to prevent the contract from renewing. What happens if the commencement date is defined in the agreement as the date on the front of the agreement and there is no agreement on the front page? Or is defined as the date of signature by the parties and either they've not dated it when they've signed it or they've signed on different dates? There's types of drafting issues that can be easily overlooked, but which can cause big issues if you end up in a dispute about whether a notice has been validly served, particularly when you're talking about a matter of days making the difference between valid service and wrongful termination. They're the sorts of issues that you may be able to mitigate the risk of by considering your contractual signing process and making sure that however it is that that contract is going to be signed ties in with somebody either entering in a date in the right place or making sure that the date is included at the end and it's obvious that that needs to be inserted. Lastly, watch out if you have an umbrella agreement or a similar framework under which individual orders are then placed. I've had a situation where there were termination provisions in both the main agreement and the order agreement that the client had signed, and they were inconsistent in terms of when the notice needed to be given to terminate and also the period of notice. Ideally, the client wanted to be in a position to terminate all of its contracts at the same time, but the wording of the clauses meant there had to be quite some thought given to that process, and it made it quite logistically difficult, particularly as this was a case in which it wasn't clear in one of the agreements what the renewal date was prior to which one of the notices needed to be given. If you're entering into multiple agreements under the same framework, then think carefully about how those agreements are going to work together in the event of termination to make the practical step of actually terminating as straightforward as possible. For example, does the sub-agreement need to have its own termination provisions, or can they all be set out in the main agreement and dealt with there? To finish off, I've included a short checklist to run through when you're exercising a contractual right to terminate. Not necessarily an exhaustive list, but just some points to be thinking about. Most importantly, and this may seem like the most obvious of all, but have you got a right to terminate? If not, then you need to go back to the drawing board. Unless the breach is so serious that you're thinking about having a go at repudiatory breach at common law, which may give rise to its own issues, you may not have any right to terminate at all before the end of a fixed term. Second, where have you got to send in a notice? Check the contract notice provisions and not just the termination provisions. Ensure they're consistent and make sure that they are followed. Next up, how have you got to send it? Again, check the notice provisions as well as the termination provisions. In a JCT contract, for example, most notices just have to be given in writing, but there are specific service methods for termination notices. The requirement set out in the notice clause is at the front of the contract and not with the termination provisions. So do just have a good rummage through, cross-refer your provisions and make sure that you're aligned with them. When have you got to send the notice by if you want to stop a contract from renewing, or when is the earliest date that you can send a notice if you are following a notice to remedy? As already mentioned, check through the termination provision and work out carefully what that window of opportunity is going to be. The next point ties into that, which is, are there any deemed service provisions which are going to affect when the notice is actually going to be served? This is particularly important if you're running up close to a deadline for cancelling a contract before it auto-renews. If you send a notice one day before the deadline, but there is a 2-day deemed service provision, you are going to potentially have problems. Next, consider whether there is any evidence that you need to keep to demonstrate service. For example, there may be a requirement to prove service by demonstrating that a letter was sent by first-class post to the correct address. In that circumstance, is it worthwhile you taking a photocopy of the envelope with a stamp on it showing the address that it has been sent to, if that is not obvious from the letter itself? That's sometimes required to trigger a deemed service provision, and there is probably no harm in doing that, and some benefits, and also likewise keeping proof of postage for recorded delivery items. You need to have a think though about where that evidence is going to be stored in a practical way so that it can be located at the appropriate time should there be an issue around whether termination was validly done. So that concludes my run through of some of the key termination issues. I'm not going to suggest it's always easy, and as I say, litigators often have a slightly smug viewpoint in that we're always picking holes with the benefit of hindsight. I appreciate that this was brief, but I hope it was useful to point you in the right direction when some of these issues arise. But as ever, please do not hesitate to contact me should you have any queries that you want to discuss. So my contact details are on the slides. Do, as I say, get in touch. We are growing our in-house community and we offer regular events and updates, both in person and online. So please do connect with me on LinkedIn, and so I can keep you updated about what we have coming up. Thank you for your time today, and I hope you will join us again next time. And for those of you who listened live, apologies again for the technical glitch. I hope you've made it this far, and thank you for joining me.